Thank you, I appreciate it so much. This is.
Check.
Yeah, I was just assistant prosecutor. This is for Brian Cox. I'm the victim. He said, I want to be here, and I want to be here.
That's fine.
He's got a living partner, ex-girlfriend.
See you later. Thank you.
Yeah. What's your name?
Sean.
And just take for your. I just want to make sure I got it right. Okay, Brian Cox. When is here on Brian Cox?
Got Cox. Says to be real. Yeah. No.
Morning.
Hi, this is Howard.
What's up?
You have a report for David Lackey.
I do not. She might be. I will, I guess. Who's not lucky?
Since Howard's not feeling good, you're taking over?
Just till she comes back.
Okay. She doesn't have COVID, does she?
I don't know. And if she did, I wouldn't know. You know what I'm saying? And which one you here for?
Fox.
Brian Fox?
Yes. It's, we're not going on the record.
Yes, we are going on the record, but you still need to fill that out. Even though it's that burger.
So I'm just putting in the due date.
Yep. Unless something else pops up.
Let's all go together. We just need to see if they have a report real fast.
Well, yeah, I just need to briefly,
You want it right down or you want to look at the report or?
Oh, no, I have to look at the report.
Okay.
Okay.
I'm waiting for Ellie from Madison, she can look. She's in there talking to the judge and they don't. Interrupt it. She's here looking for a report on a criminal case.
You got the report on the Lomax, Mr. Lomax, David, excuse me, David Watkins, David Watkins.
What is our report? Is our report,
Report clinic.
okay.
If we need to get it moved to get it reported, you know.
Well, she had told us, Rick is answering the question, I asked, be a tax rate and answer. It was an applicant, actually, already.
Yeah, yes.
Oh, no, but she was like, yeah, the voters are in there. She was there.
Sorry.
That's what they said. That's what they said. Well, we can also do it for the running around us, River City has rules. Just. How did that was scheduled for teaching?
Hey. I don't know why. They called me and told me to come in. I just asked them not to get to. I said, yeah.
When they go.
Again, yeah, this morning. I said it's 26.
It's jail, and that's about right.
No, it's probation.
It's probation.
It's jail.
When you send it out, another good one. Okay.
I mean,
How's probation involved?
I guess they gotta make sure somebody comes to it. I am the family.
Okay. I'll have one for the jail.
Go check the jail records. Okay.
It's no problem, yeah, it's moved to a different day, and they don't have to report. It's all right.
You did? Okay. Yeah. Okay. Well, they had
I can give you something to do, let's do it.
He's got like 2 years.
Well, it depends on what they say.
Yeah. Michael's not letting it. I was going to take him.
He's sure.
He's smart.
Probably similar to how. Well, thanks for that.
It's no big deal, it's not a report I told. I think they're busy.
Oh, I see, you fixed your hair.
Okay.
She doing?
No, I'm going up. Everything's okay.
I have a hearing at the 10th on, Targalia Woods. I've been here, I'll be back, I'm running around, okay?
Who do you got?
It's with Merlin and Brett. I'll be here.
No, you too.
Targalia Woods. Hey, this guy, I got it. Yeah, we're running around, we'll be here soon. Not as soon as possible, okay? Morning's going.
Yes.
This is the presentation. This is the This is really great. This is actually much less than this. Anything that like this.
just writing this report and it's a draft. I can review it and then get it back.
I would ask her. Okay. Yeah.
It's aggravating.
I don't think
I want the prosecutor in there.
Oh, they go, is he not here?
Yep, he's gonna start out.
Okay.
All right, the separate session of the Hamilton County Common Pleas Court is now in session. The Honorable Wendy Cross presiding. Please be seated, remain quiet, turn off and put away your cell phone.
I've been on the Zoom for the last 10 minutes, Judge. I'm on Zoom. Good morning, everybody.
Good morning. Is your client on Zoom, Mr.
I'm sorry, Your Honor.
Is your client on Zoom?
Yes, Your Honor.
I didn't. She wants it. When you're client. Mr. Lewis, I'm ready for your case when the prosecutor gets involved.
Yes, Your Honor. I will be
And your client is here on, my Zoom.
Yes, Your Honor.
Okay.
Just a status, so, sure. here. I'll be sure to just.
Thank you.
May we approach?
Yes.
Sorry, Judge, I wouldn't be here. No, I was on my Zoom.
Where do you want me to All right, this is a matter of State of Ohio versus Darius Hampton, case number P2101597. Mr. Hampton is appearing by Zoom video conferencing. Mr. Hampton, I'll need to see your face. Hold on one second, I'll be back. Okay, here you are. And Mr. Carl Willis is present in the courtroom along with Mr. Mark Tierney representing the state. This matter is set for a status report. I know this matter is up on appeal, the briefing schedule, but my understanding is supposed to be done by the 13th. Where are we?
May it please the court, Judge, I received notice from the first district and appellate counsel for the state of Ohio that they filed a brief on the 13th as required. We're now going to take 45 days to get our response in, and I think we're going to have hearings, so our brief is due in 30 to 45.
All right. So we will continue this matter 60 days for status. Can we get a date, 60-day status date for Mr. Hampton's case here?
How about February 14th at 9 a.m.?
Works for me.
All right, January 14th, 9 a.m. All right, I'm gonna, note for the record that the defendant is present via Zoom. I'll ask if he be present via Zoom at the next status, which is February 14th at 9 a.m. And, we'll just keep holding this case in advance until that time.
Thank you, Judge.
Thank you very much. Thank you, Mr. Hampton. All right,
Good morning, Earl.
good morning.
Well, Mr. Chairman, is up. This one I wouldn't want to be recorded.
Oh, okay, yes.
I just didn't know since we stand here, it was recorded.
Yes, okay. Yeah, why don't we,
It's starting to do it here. Yeah, we just don't.
oh, so, okay.
Yeah, it's not be recorded.
Okay.
And I don't know why. That's very unusual.
Okay.
I think it's Nick.
Want to continue at 30 days? Yeah, let's continue 30 days. All right, Ms. Hopkins, if we can continue stop 30 days, please, for clear trial setting. That was Scott. Yeah.
Thank you, Joe.
Looking at, January 13th.
I'm not in town the whole week. The following week is fine.
The following week, maybe he's out of town.
Okay, how about January 18th at 9 a.m.?
That's perfect, that's good.
All right, perfect. Good, Mr. Chairman?
Yes, Your Honor.
All right, January 18, 9 a.m., you said?
Yes.
9 a.m. Is he here?
No.
Okay, that's fine. Thank you, have a great day.
Thank you.
All right, Ms. Rosie, you're up. Good morning. Good morning. I'm just trying to get a good handle on what we're doing first. Okay. Thank you. All right.
Hi, Judge. Your carpet is awesome. I love
It's
it.
clean.
Yeah, it's so great. Would you be able to call me?
Yeah.
Dave Lackey.
Yeah, do you want to sidebar or do we calm down?
Sidebar would be great,
All
Judge.
right. All right.
It's so great, so better, much better, and it's in squares, so that if something gets on it, they can just pick the square up instead of replacing the whole carpet.
Oh, that's awesome.
Yes. Okay. He's not,
He was found not qualified for NCR. I've already consulted with the public defender, and they've agreed that they would pay for a second opinion. And I'm asking if they interested in also paying for a second opinion.
okay, is he gonna cooperate?
He did it for that property. We did that at first lady, but once this lady went to the And, I'm just asking Your Honor if you would ask the court to share. They have so many documents. If they would share that with Nancy, it would make things so much faster.
Gabe asked us not to do that. They've come and put a whole presentation over to the court, about what works and what they are asking us not to do, so.
The only reason I ask is because it just moves things along faster, and it doesn't really make any sense.
Mm-hmm. Yeah.
Why would they ask you not to do that?
So you are definitely going to get a second opinion?
I am, and Jack has already approved it with the public defender's office.
All right.
Yeah, my whole thing is, Judge, I haven't made my school work to the report yet, but some of these are historical. And so for an NDRI, it's like, is he cleaning a period of years? I just don't know legally if that's like available in this type of case. Well, since I've met him, he said delusions. I've never talked to him when he's not professing some sort of delusions. The other attorney that was going through with Social Security got approved. He's been working with him for years, got approved. Basically, while he got arrested, and it was for mental and physical problems. So he'd been seeing doctors for years.
He definitely has mental problems.
Yeah.
That's not any dispute.
Nancy, she's going to do these for the
She does that. She's been doing it for over 4 years. I think this is very serious, obviously, raping young children, so that's an allegation.
Oh, I just didn't know legally how that works.
I just know that he was seeing,
If you're not supposed to be reading insanity at the time of the offense, like, if they assessing him for being insane for all the periods of the indictment, which is historical, which goes. I just,
Yeah, what is the period? What is the time period?
so I mean, it's definitely at least like 3 years, maybe 5 years, it's a period I haven't unpacked my baggage to get the private judgment. I can certainly do that, but I just was thinking about that is because, the court kind of called me as well, and I was, candidates, I don't know what their standards are and who makes these determinations, but just so you know, this goes back.
well, I can just say that he had a Social Security, he was seeing several doctors, probably over a 3 or 4 year period.
Well,
And he was ultimately diagnosed, I can read that he was
So I'm not a doctor, I'm not a psychiatrist. I
How
don't
much
just know.
time did?
Can we come back January 20th and then we have a jury scheduled for the end of February?
Do you have, will you have a report?
I will.
Yeah, Judge, I just also wanted to briefly talk about the kind of scheduling order that we have in this case. The trial is set for the end of February, and given all of this, is that, are you holding us to that?
Well, we may have to adjust, depending on the second opinion. We may have to adjust, so,
Because then we'll have to have a battle.
not necessarily, is what I'm saying.
Okay. A battle with the experts, I guess,
Right.
where your honor will decide, and I just, when you have trial victims like this, there's a lot that goes into preparing them for a trial, and I just wanted to be realistic with them about what we're doing.
Well, we definitely have a lot of time because all this is waived, and this is all the speed trial waived, so we have time. I will likely continue the trial. I'm just not gonna do it today.
Sure, okay, I just wanted to.
Yeah, so, yes.
Okay, great.
Okay. All right, so can we get 30 days on Mr. Lackey, if you waive his presence?
I waive his presence and like fine, but just for the record, Your Honor, can I get it just for the record as far as that we're asking for that?
Yeah.
How about, January 18th at 9 a.m.?
Is that safe to work for you?
I can do that.
January 18th?
Yes.
9 a.m. All right. So this is the matter of State of Ohio versus David Lackey, case number B2101580. This matter is on today for a status report. And there's been a referral to the court clinic for the defendant's mental condition at the time of the offense. I have a report dated December 13, 2021. And counsel, have you received a copy?
I have your
All right,
honor.
have you seen a copy?
Oh, I'm making my way through it, Judge.
All right. For the record, Ms. Jody Ganote for Mr. Lackey, Ms. Allison Oswald for the state of Ohio. Ms. Ganote, your client is not present, he's the Justice Center. Do you know who you brought over? I'm sorry.
I can wait it.
All right, thank you. What would you like to say?
Just, Your Honor, that I have had an opportunity to review the report. It indicates he does not meet the criteria for MGRI. We would not be stipulating to a report, but we would be asking for a second opinion, which the Hamilton County Public Defender's Office has already approved. The hiring of Ms. Nancy Schmidt-Gosling. And I feel that she would be able to get the report completed by the next hearing day that we've just scheduled for January 18th. The only thing that additional I'm asking, Your Honor, is the report indicates a number of facilities of which the court clinic received records. Obviously, Ms. Schmidt-Gosling could do the request for those reports also. I've already indicated I do have a long, lengthy amount of information that I received from a Social Security attorney. I'm just asking the court to please consider those that are not from the attorney to share that information with Ms. Schmidt-Gosling. It will remain private. It will, she will obviously has the opportunity to do that herself. It just makes things move along quicker for the court. If she would be able to get copies of those records that are just for her benefit and mine, we're asking the court to consider that. I also just want to put on the record that since I've met Mr. Lackey, whenever I talk to him, he professes to have delusions, so this is why I'm asking for the second opinion.
All right, State.
Judge, the court can decide how it's going to handle the request of the defense expert, how they're going to handle those private records of the defendant regarding representations about the defendant's hallucinations on the record to the court. I would also be in a position to proffer jail phone calls where he's plotting with his mother how he can get to Summit because he can walk around freely in Summit. He'd be more comfortable at Summit. So I do believe that he's not presenting in a forthright manner, and that will all flush out in these evaluations.
The only thing I would add, Your Honor, is I've never been given any of these calls, and I've never even been verbally told about this until this moment. So,
All right, is the space stipulated to this, Court Exhibit 1?
The state would stipulate.
All right, so, the state stipulates to the, report dated December 13th, 2021, report written by, psychologist Dr. Emily Davis, which, who gives the opinion that, the defendant does not meet the criteria for NGRI or not guilty by reason of insanity. The defense, does not stipulate, and is asking for a second opinion. I will continue this to allow the defense to get a second opinion. We will continue it to January 18th, 2022. Right now, there is a jury trial set February 28th and a final pretrial conference set January 27th. I will tell you now that it is likely, given the situation, that those dates will be continued. I'm not going to do it today, but certainly we'll address it again on January 18th, 2022. The court is going to admit this report as Court Exhibit number 1 under seal. I do realize the defense is not stipulating to it at this time, but it will be admitted under seal at this time, and we'll come back. Are you confident that Dr. Schmidt-Spotsling will have the report by the next time you come back?
she believes so, she feels confident, but Your Honor, it would be easier if she could get those copies. That would make everything one so much bigger, things that she can get anyway, and then just.
All right.
Reason that there could be a delay.
All right, so I believe that the Dr. Schmidt-Spotsling is able to get the same records that the court clinic received by way of a subpoena. If there is some issue, Ms. Note, please feel free to come back to the court, but at this time, I'm not going to order the court clinic to give those records over.
One thing, Judge, I believe the court has already admitted a competency report, so that might be Court Exhibit 2.
This might be Court Exhibit 2, that probably is A actually.
Or whatever, I don't know.
But thank you,
Okay.
we'll make sure that we don't make duplicates. All right, and then very much, any wait time? Thank you.
Is the court giving the parties a copy of these reports?
No,
Okay.
they are to be returned.
Can I come back and read it?
Sure, absolutely. You're always, free to come back and read it.
Thanks, Judge.
Mr. Hamadula,
Yes.
are you ready to size?
Yes.
Yes.
Good morning, how are you doing, sir? Spoke to the footprint structures in the.
Did you see the report?
It's a report to come to
Oh.
the 17 metrics. Our suggestion, start classic access. And then we come back here and see what we consider as it. Okay. I'm okay. And then she wants to-
Did you see the report? Okay, well,
if he wants to do it, we'll do it.
you guys will do. I'm sure we can start.
Not to be in the middle.
Oh.
Might even get in trouble with that.
Is she here? Close to. So,
Do you think they can
She can make it, it's testimony, she can make it through it, and I'll be impressed about it.
I know.
So, yeah, maybe this would be, if we maybe give you a couple weeks, I know we're, we put some, and then I'll be able to bring some documentation from that, so it's,
Miss Hopkins, can we get first or second week in January and size more?
January, 4th at 9:30 a.m.
I'm down here for all the cases, so it's a good day, or you, or I can get anything. Okay. I'm gonna figure it out, yeah, I'm the only one that can't do it.
Okay. He said the fifth would be better if we can.
Okay. Two motions to suppress, I don't know.
Oh, okay, well, yeah, they start at 10, they start at 10,
Yeah, okay.
so
So,
9:30.
yeah, we can do 9:30 on January 5th.
All right, thank you. All right, January 5th, 2022, 9:30, please to be present. Please make sure that he doesn't have to work. All right, I will see here that day, so that means it. All right,
You want to sign something?
yes, thank you.
Is Brian possible?
Yes.
Good morning. Check with control, we already did the
Yes, gonna go. Thank you.
Oh, I'm sorry.
All right, so. Yeah, it's on the tape.
I have one witness. Two.
Gotcha, okay. A week?
Actually, I haven't done a jury trial. So it's set on Monday. Do we pick the jury on Tuesday?
Yes.
So we pick a jury on Tuesday.
Yeah, we don't leave them on Monday, we have one.
Right.
Pick it on Tuesday.
Pick it on Tuesday.
Probably 2 days.
If,
Yeah.
So I guess 3 days. So there's no video. So it should be pretty. There's no video of the incident. There's somebody on camera. I'll be salvaged or something.
Obviously, victim.
Victim, so it's all the individual.
Yeah.
And then we have the individual that is my phone.
All right, so the Friday before, those jury instructions, put those in the Word document. Also, the motions of Monday, what you're gonna do Friday before, and.
Now you can get self-defense. Yes.
It's gonna be self-defense, okay, it's not that you want you to.
Jury instructions.
Your jury instructions.
And your self-defense. Well,
Yeah,
and I'll probably, if you want to do file motions, because there's a vehicle, but it's not a vehicle. So it has to document, it launch, I'll just research.
All right.
There's a corporate free.
I'd like to have, you know, I know it's gonna be witnesses, but it sounds like it, but I'd like to have a summary on witnesses. Soliciting, not what they're gonna say, they're soliciting and exhibits you're gonna use.
That's Friday before.
And, how have you had your jury trial since the new judges yet? Okay, so we'll do the first one.
Of the new class.
Yeah,
Oh, I'm correct, yes.
okay, we don't do anything earth-shattering, new at all. Just, you know, idea to the box and then put those in.
And then you get what your votes.
Engage people by your rules, right? I use, on my pre-trial order on the website, it says I limit you to 30 minutes, but That's not really true. I'm gonna update that before, the new year. But I don't give you all day. So I will. So you might want to plan on about 45 minutes, especially for a case like this, about 45 minutes.
Yeah, there are a few burning topics, especially self-defense, obviously.
Exactly. But obviously, if, you all have to, go over it, that's fine. But I just really want to impress upon you that you don't have to do 2 hours of jury. So, all right, any questions for me?
No, there's there's 4 different judges in each one.
I know, that's what I was,
So
yeah.
we'll figure it out.
Yeah, it's nothing earth shattering.
Right.
So, all right, thank you.
Thank you so much. We don't need to run like we've already got to take
No,
that.
yes, sir.
Thank you very much.
All right. Mr. Boone, Mr. Blazer, and then we're ready for our citizen. Is Mr. Dark? Mr. Sugarbaker?
Yes, Your Honor.
Is Mr. Dark outside? Is Mr. Dark outside?
I've not seen it.
You have not seen him?
He was in the room.
Okay.
Okay. Said he got through.
All right. We're gonna be ready. Are you ready, Mr. Julie? All right. Okay.
I got started at 36,000. You get it, you'll put it. You get it.
Has Mr. Brony been in?
Oh, he's just talking.
Everything all?
Oh,
I'm ready now. Mr.
She's doing preliminary discovery today, video coming.
He's out.
Oh, yeah, he's out, we have a probably info.
Is he here?
He's not here today.
All right. His presence. All right. Ms. Hawkins, on Donahue, we have 30 days. Mid to late January.
I'd say, January 19th is open, so January 19th at 9 a.m.
That will, okay, great, January 19th.
Thank you so much.
Hold on, one second, we have an entry for you. At 9 a.m. January 19th, 9 a.m., lay a time.
Thank you so much.
She said she had through the phone. She hasn't talked with me.
Oh, okay. Well, then just let her do what she's supposed to do. I'm ready for, let's start that. So wait, let's do Carter, Mr. Ronnie, and Mr. Sugarbaker. And we're ready. Is everyone in the courtroom for the evidentiary hearing? Okay, ma'am, are you? Okay, yes.
Yeah.
His lawyer, Ms. Blazer has been here, and, I don't know, she might have gone up to see him, and then she'll be back.
They never were on this. Come here, Judge. I don't know, just Just want to make sure they weren't coming this way.
Appreciate it. Hi, Mr. Drawing, you ready?
Judge, I just saw Mr. Sheriff Director out there, and Mr. Clark was in a different courtroom. I'm gonna try and round up, of course, okay with that.
Yeah, we were ready, supposed to be ready at 9:30. I'm running a little behind, but I'm ready now.
Sounds good, Judge, I'll try and round up.
All right, thank you.
Thank you.
Yes, thank you so much. This,
Yeah. It's,
thanks.
Hi, Julie Deputy with Furniture, I just wanted to introduce myself. Hi, yes. I just realized this is, since I introduced your previous position.
I know, all the words. Yeah.
All right, we have 2 out of the 3. I think Mr. Groning needs to go find you 2.
Yes, just here.
Oh, he is here.
I have, 2 other matters to attend to. I hate to make this go away, because I don't know how this may, just until we know how we're gonna proceed exactly.
Why don't we come in my house?
That's great.
Mr. Groning is here, you just send back, I don't think it's gonna take long, but. Uh-oh. I think about that. Oh, my God. You can't go in there. No. We'll have to have somebody come. Let's go in the back here. Can you, ask, Megan? Megan, something like to unlock my door. I forgot to push the little button. Unlock that.
Hey, Judge. This, here comes the video. Good, okay, so there's process.
Good luck with that one. Okay, Hope, are you guys staying in town or are you going out?
No, we're not going anywhere until March.
Go ahead.
How about you? Oh, the chamber.
I got it unlocked right here. I got this door unlocked.
Okay, can you unlock this one too?
Which it leads to the same door. I didn't want to unlock that one.
Yeah,
I
because.
got this one unlocked. I didn't want to close the door. You're welcome.
Thank you. Thank you so much. You're welcome. You're welcome.
Oh, just a few short minutes.
Okay. Well, you definitely can still turn it on.
I mean, I gotta get this done. I mean, we'll wait. I can text the mayor.
Okay.
Thank you.
Yeah, yeah, great. I'm looking right now. If he did it. Controlling or. I don't think he was. Oh, here it is. Union Gap. I guess it's the solution to make that up. Sure. I need to. We need to call. One seven four zero. Just me, it's not.
He gave me a credit of 600.
Yeah, okay.
So they keep 61.
He's getting out.
Wow.
That's why that information card is. Yeah, right. Okay, we'll leave you. We're gonna.
Yeah. Yeah. Absolutely.
Because I called Tracy, who's in charge of the owners. The numbers are correct. We're just saying about that.
They're always. Right.
Hey, you I don't know when they're still in. Yeah, she took over.
Oh, right. Okay.
Lord says, I don't wish to get it in this, this going on.
Yeah.
So can I get you? Retired is every second of it. Yeah, he's totally retired. He gave up his license and everything.
So he gave me the position.
I mean, he's not even one. He's enjoying knowing himself. I talked to him about a month ago.
So he said.
Oh, yeah, he just sat down on it. And the old post building. Remember he said that he lives in women's shoes? Remember?
Yes.
I think my favorite line is, we're going to church. Me and John sound like an old married couple. Whatever John tells you to do it, not because I'm always wrong. He gets right to business, but he's also got such I'm 65 and I'm only 60. So, because there's no health insurance for working, or they give you a choice that they're even covered. I think he's older than I am. But you still got to buy a supplement plan for Medicare. And we drug plan. And this. Right. You're talking, I think they're $1,800 a month. $1,400 a month. Oh, yeah. Easily. And a lot of times they don't cover if they have any medical conditions. Under state statute, they only have to guarantee your pension. They don't have to guarantee health insurance. Yeah. Because they didn't think when they made that healthcare would go away. So when the state legislature made it, okay, we're guaranteeing your pension. This insurance, what do you do with it anyway? So, you know, OPRS, we'll cut the budget.
We need 20. I'm 60. How's Gina doing?
Yeah.
Are you sure?
When she coming back?
Oh, perfect. Okay.
I said you never wanted. No, it's just, you haven't had any updates.
She's here. The court man.
Are you guys ready?
Well, we are here, there is a partnership on both defendants for our yeah.
Okay, no worries, I just want to make sure. All right.
Sure.
I haven't filled out yet, so I do
Vicky's not been over. Sweet. This thing, she's got a major, put her on the 50 every 3 days. She's 100%. I mean, I'm gonna watch stress, but yeah, I mean, she's still functioning. She's done a lot of things. It's in her back, left side, or right side. Yeah. We check to make sure we're doing good for her. You know, that we can be, she has a massive one for a right one. I don't think it, she won't go back to the one.
Yes.
Because of low function and her lung, so. I told you, she said, period. So we just do what, I do what I can for. I said, and the doctor told me I had to talk about hospice. She goes, are you ready for that? I mean, hospice, she didn't do 10 years. She's used to the old way where you go in and you got. The new way is they come in, they help, they, all this.
We're going to start all
You want me to ask?
Yeah. Today, I mean, I'm not a decision.
I know, that's what I'm saying.
Yeah.
I agree.
So why are you?
Why
Why are you running? Well, I'm going to
make a statement.
I just.
Another gentleman agreed. And she, partial registration to the defense. I don't
Yeah.
So, yeah, there's a registration there.
Oh,
It's not gonna play out.
Theoretically,
I mean, I guess my wife, I don't know. You know,
Talking about being trying
yeah. 13, 11, and just turned 7. So pretty good. Doing very well. They're ending it. They've already gone on. We're going to, and going started, I'm going to, so we're kind of running. So we're coming to those folks that take it that my wife is very, she's a teacher. She teaches actually at my youngest school, elementary school. And my kid, my other two went there. Now, their middle school is about an hour and a half, too close for buses, you know, so it's like Americana, it's nice. We're not our neighborhood. On the west side, this neighborhood's called Sundance, South African Run. That's right.
So we'll do that.
Yes. Although in some rooms, so we're just, it's fun. I'm trying, I'm old, I had kids later, you know. I had kids later, that's not bad. Sorry about that. Oh, I know, I'm already, I'm can't watch news after I get all of them. It's hard. I'm always sad like a girl. I know it. See it coming.
Are you gonna go? You can't go.
Come on. I'll be 50. I mean, there's a light at the end of the tunnel, but I'm afraid it's a train. I think, you know, there's never a good time to get married, to buy a house, to have kids, to do it.
Please see the quiet for executive session.
All right, council, Ms. Glazer.
Good morning, Mark.
Good morning. This is State of Ohio versus Joseph Putnam. Case number B130571. This is a pre-conviction case return. Miss Attorney Angela Glazer is present on behalf of Mr. Putnam. Mr. Garber, will you stand for the state?
I shall.
All right, Mr. Craig Dark for the state of Ohio. This, Ms. Glazer, you were just appointed on this matter for Mr. Putnam. What would you like to do today?
Judge, it's my intention to address his bond, but I have not been able to speak with him upstairs, and I understand the court's calendar this morning is a little tight, I think we're starting a hearing. He was locked up for 4 years in Kentucky, was transferred here to address this felony 5 case. So if I can't address his bond today, or we don't have time, I don't know if the court has availability tomorrow possibly, or as early as possible, so that I can try and make a moderator on his behalf.
Tomorrow we are scheduled, all of our hearings are scheduled by Zoom.
Okay. Let's see, not around Friday.
Friday is our DSC day and, those are telephone reports.
And the court would not be inclined to address this bond without him here, correct?
Without what?
Without his presence here at the court.
Correct.
What about Monday, Judge?
Yeah, we can do it on Monday. The 20th?
Yes, Judge. I can be here early that day as well.
All right, so let's, continue this to December 20th. We'll put it at 9 AM, but if we get here a little before then, we'll go ahead and address it. Wait time.
Yes, Judge.
All right, so this is for Mr. Putnam, so we'll give you an entry and we'll continue this to Monday at 9 AM, okay?
Thank you very much.
All right, thank you.
Thank you.
All right, this is a matter of State of Ohio versus Andre Garbahi and Cameron Bost. Is it Bost or Bost? Bost, okay. Case number is B200-0380 A and B. This matter is set today for sentencing, and it's my understanding that the parties wanted to present, may present evidence and argument with regard to restitution. Mr. Tharp is for the State of Ohio present. Mr. Brad Roney is present for Mr. Boss. And Mr. Merlin Sugardecker is here for Mr. Garbahi. Mr. Tharp.
Judge, in speaking with my victim, Alfred Berger, I explained him the situation. He is crystal clear, he does not want a restitution hearing. He would hope to address the court. He is advocating for prison for both defendants and does not want a restitution hearing at this time.
All right, so just so I'm clear, there will be no evidence presented on the issue of restitution.
No, ma'am.
All right. All right. Yes. Yeah, thank you. All right. So I'm gonna make sure that the parties have received the reports from the court clinic in mitigation of sentence. Have counsel for the defense received those?
We have, Your Honor, we received the victim impact statements, pre-sentence investigation, and the report from the clinic.
All right, thank you very much.
We have voted on it.
All right, thank you very much. All right, well, State, want to start with presenting whoever you want to
Yes,
have
Judge.
speak on behalf of
Yes,
the
Judge.
state?
We have two persons today that we have Alfred Berger, our victim. We also have a supporter and an advocate, a good friend of his, Mr. Kerrigan. Mr. Kerrigan would like to speak first, I believe. He will be extremely brief, is my understanding. Is that correct, sir? Would you like to speak?
All right, sir, you may come up to the podium. Mr. Darby, will you make sure that's on? I think it's on.
Sure. That's
Yes. testing.
Hello?
Jacob, that's-
Testing.
Is it on now? Now it is, yes. Now it is.
Is this working?
But they just saying,
Is this working?
It's not working as much as it should. I think that would be good, I don't turn it on so too high.
Working? Is this working now? Sorry, it's hard.
Is it?
I didn't see one.
Okay.
Working?
No, we tested again.
Yes, sir. What are you recommending? Working, hello? Working,
As far as we get.
Yes, sir.
I think it'll be fine. All right. Sir, if you wouldn't mind coming to the podium and stating your name.
My name is Eugene Carrigan,
Eugene, will you spell your last name, sir?
Carrigan.
All right, Mr. Terry, what would you like to say?
Your Honor, I'm pleased to address the court today. For 231 years since Hamilton County has been established, we've had an elected judge in the judicial system to help represent and protect society. We need to take a good stand and honor the tradition that these monsters that come along and torch and arson and breaking and entering people's private property need to be prosecuted to the full extent of the law. I ask today that you sentence both parties to the maximum that they have pleaded guilty to. Thank you.
Sir, can I ask you are you a supporter of the victim, or are you a business owner?
I am the supporter of the victim.
All right, thank you very much, sir. All right, Mr. Clark.
Thank you. Next person will be Alfred Berger, Your Honor. I believe he has a prepared statement he would like to read. Is that correct, Mr. Berger?
That's correct.
And I don't think this is on, so if you just keep your voice up, please.
All right, good morning, Mr. Berger.
Good morning, Your Honor. I would like to read a prepared statement that I made and log in explaining my situation and the situation of the case at this point. And I'd like to answer questions afterwards if you have any questions. I'd like to explain it as best I can. My name is Alfred J. Berger Jr. And this report is presented to the court by myself to reflect and describe the seriousness of the offense carried out on December 14th and 15th, 2019, 2 years ago today. By the two above-mentioned arsonists convicted of aggravated arson, working as a team to destroy the iconic building complex known as the Jackson Brewery. For investigations, it was their admitted goal to destroy this building precisely because it was an iconic building. This case has been continued 19 times, where I attended each and every continuance, and there was never any remorse about what they had done. But worse, bragging on social media that they had accomplished their intended goal. During this 2-year period, these two defendants, by posting bonds, were able to walk the streets of Cincinnati. This made me fearful daily since I own other buildings and in the area, that they could also have been thought as iconic and were at risk of being damaged or destroyed for 2 years. So it is the court's responsibility to promote respect for laws and to promote just and sound punishment when these laws are broken. It is the court's responsibility to deter defendants and others from criminal conduct and the court's duty to the safety of our society. It also is necessary for the court to avoid any disparities in sentencing of the defendants when none is actually justified by the defense. Since Mr. Boast has confessed his crime, he has been again posting online and complaining that he is now a felon and charged with aggravated arson just days after pleading guilty in this court to the judge of the exact crime. What exactly was the crime that was committed on December 14th, 9th, in 2019, exactly 2 years ago? On this night, this team broke into a truck parked in our fenced-in property, stole the tire jar iron. They then went and broke into the rear garage door of the Jackson Brewery. They entered the building with the intent of burning it down. To ensure their success, they dragged a large propane tank, which was half full of propane gas, and used this source of heat to help accelerate the fire. The fire quickly spread throughout the upper floors and the roof of this historic Jackson Brewery, the flagship building of a prominent business that was started in 1829 and named after the then president, Andrew Jackson. Their deliberate actions resulted in a 4-alarm fire with about 60 firemen fighting the blaze and pumping about 1 million gallons of water on the fire before it was put out. It was 1 million gallons of water. As I watched my building burning at 4 a.m., Art Dahlberg, the head of Cincinnati Buildings and Inspections, pressed me to tear the structure down immediately, where he said that the city would tear it down for me at my cost. It was only my lawyer who was present at that prevented the city from demolishing the whole complex and leaving me with many thousands of dollars of demolition costs. The emotional strain that night, seeing that many years of restoration work that I had done on this beautiful building was going up in smoke with no insurance, and for me, the question, why? It was almost too much to bear. The defense would like to describe this offense as one that some careless youth just wanted to have some fun and torch an empty derelict falling down on an occupied shack. Nothing could be further from the truth. This building is total of about 100,000 square feet, with almost half the structure below ground, comprising about 30,000 square feet of laundry tunnels, which was used historically in processing of the popular lager beer. This building was the best example of the unique architecture of the manufacturing sector of the Cincinnati beer industry. Financial considerations, I assembled 14 parcels, which now comprise the Jackson Brewery complex over many years. The building is spread over 11 parcels. The other 3 parcels were purchased to provide access to the building. Some of these parcels were purchased through tax sales, but the sequence of these purchases was key to creating the value of the complex. I have worked on this assembly for almost 10 years. The substantial structure, some built in the early 1850s and renovated several times, was in very poor shape when I purchased it. Water contributes to destruction of many wood and masonry buildings. The roof failures caused most wood deterioration. The structure needed a new roof, but the timber frame construction had been severely deteriorated under that bad roof. And when the roof was taken off during a period of years, the exposed timbers were carefully inspected, and most had to be replaced. The masonry brick was also spalling. Brick had to be replaced, and walls outside and inside had to be tuck pointed. Timbers had to be sourced and fitted together to replace the structural supports that held up the roof. This structure was continuously worked on by a dedicated team of tradesmen for almost 10 years. My investment goal was to do the hard stuff and to present a developer with a sound, stable structure and platform for a grand mixed-use development with a superb view of the city and with soaring interior spaces, and which included the best underground tunnel system in the city. My out-of-pocket costs in the years 2012 to 2020 were my costs were $2,492 a month, $492,248. Backup detail I gave you in my printed report. In the remainder of the statement, I will try to show what a terrible loss this has been, not only to me, the curator of the historic building, but for the city and its redevelopment, for the surrounding neighborhoods called the Brewery District, and for our country's cultural history. This was the destruction of one of the greatest buildings of our city and a cultural crime against us all. The Jackson Brewery was the centerpiece of the restoration of the northern half of the Rhine area of Cincinnati. Surrounding the Jackson was the Brewery District, and it promoted the neighborhood use of the Jackson for thousands of brewery cellar tours. It gave rise to the major neighborhood walking tour promotional project that had a $5 million budget. The Brewery District Association was responsible for the Bachfest parade and weekends. This excitement brought on millions of dollars in development of neighborhood breweries, distilleries, residential and commercial development. This success radiated nationally, promoting our city and the country at writ large. Finally, this arson case has been continued and delayed to include a change of judges, almost 20 continuances, and fully 2 years of delay. In this case, justice delayed is justice denied. Stepping aside to the various reasons for this delay, the repercussions of this delay have been the ruining of my reputation as a permanent restorer of historic properties in this town. Multiple negative encounters with the city in regards to its use and repair of the site, plus the loss of possible purchasers. My loss includes the loss of years of planning and research expended for the site and dozens of sleepless nights with worry about the Jackson's future. And of course, there is also millions of dollars of financial loss and getting this site stabilized with the city code that to be viable for sale. In summary, I believe that restitution will never come to me from this grievous crime, and that the perpetrators should at least pay for their crimes with the maximum prison term called for under their already negotiated sentencing rules. And Your Honor, I have a book here, I think you might have seen it recently, that is the printout of the total of the statement. It's got pictures, it's got reference material, it's got the whole thing. So I hope you get an opportunity to look at some of these things. This has been a terrible crime. And I'm open for questions.
So that book was basically a printout of all of the email things that we had sent in PSM, victim impact, that was sent to the judge, is that correct?
Yes, yes.
So just to be clear.
All right. So it's all information that I received.
Yes, ma'am, I believe so.
All right.
Other than that statement that was included in the book.
And Mr. Berger, I just want you to be clear on, I want to be clear on what you're asking. You're asking that there be a prison term for both of the defendants, and that you are not asking for restitution, even though you just summarized that you have been out of pocket a substantial amount of money.
That's correct, Your Honor.
Um,
Basically, I was disappointed when at first the charges were much more serious than they are, and they've been negotiated down and down, as well as prison terms as well, were negotiated down, as your guidelines would tell you. So that's already, this is my first time in front of you, Your Honor. I've had no opportunity before to bring my case to you as a victim. And so at least this negotiated down situation, at least at that point in time, they should be able to get the maximum the maximum sentence of the negotiated time. We cannot continue to let people burn things down with no serious, what do I do for if I wanted to have restitution? Nobody can get it at this point. I gave you the idea of the amount of the loss that I had. So that's not going to go anywhere as far as I'm concerned. I think these two gentlemen do need to understand that this, and the message that goes out to the city at large, and there's a lot of iconic buildings in this town. And we can't just say, well, let's burn another one down. We're not going to build another. This building, the courthouse, had been burned down at one point in time. You don't want to have that. So I plead that you would consider that in your judgment.
Did you know either defendant before this happened?
No, Your Honor, I did not.
All right, thank you very much, sir.
Thank you.
Mr. Dart, anyone else?
There's no one else, I believe I should place some things on the record to correct something that's in the PSI.
All right.
The PSI judge, I think, it indicated that my firemen were asking for 3 years in prison for the defendant, their guy who began to propose. However, I believe that that's incorrect, Judge. In speaking with them many times, they were in agreement with just going along with whatever Mr. Berger said. But truly what they mean is they were just going to stand silent and make the decision not to even. I've discussed that with them many times. So I think that maybe that was an error in the PSI and the victim impact for both defendants. I also have to say that while I understand Mr. Berger is asking for maximum sentence for both defendants, we pled open. They knew entirely that Mr. Berger would ask that. Our negotiated plea was to stand silent as the sentencing. But I can tell you that Mr. Ghost, from the inception of the investigation, we believe that should stay on the record. He should receive some case consideration. As a matter of fact, he already has in a way because of the way that he's able to plead. And that was at the urging of the federal prosecutors. So I had to place all that on the record. Okay?
All right.
Any questions about how I explained that, ma'am?
No, so I just want to make sure the record is clear that the fire department representatives, marshals, do not make a recommendation on sentencing.
They stand silent as a sentencing judge.
They stand silent.
They leave it completely up into your hands based on the plea and based on the information you have.
And the state is also standing silent.
Yes, we will stand on our victim statement. But I have to tell you that as far as the Mr. Ghost matter, he should receive consideration as well as at the urging actually of the fire investigators as well, as he was working to cooperate throughout the.
Well, let's be clear about this for the record.
Yes.
The case consideration that Mr. Boss has, is to receive came by way of the plea, not by a court and what I should do, correct?
Judge, I believe that would be the way, the correct way to phrase it, is that correct, Mr. Graham?
With regards to the court, Judge, it's always my understanding with regards to it that prosecution is not political probation.
That's a fair, we are either way, Judge, with Mr. Rose, that's fine.
All right, so, hold on, let me, we have to make this clear. So, whatever negotiations the state had with Mr. Boss, it was the state's and council's position that Mr. Boss would receive case consideration for his cooperation during the investigation of the case that involved how he was able to plead, first of all, which is of F4 arson, single count, and that the state at sentencing would not oppose probation and would stand aside.
That's correct.
That's the case consideration. All right, and that's accurate, Mr. Grony?
That is, Judge.
All right, I just want it to be clear that whatever case consideration that the parties envisioned did not bind the court.
Yes, sir.
All right, thank you. All right, anything else?
Just to make it clear, in my office, our policy is that we are not allowed to enter into an agreed community control.
Understood. All right. All right, so let's start with Mr. Dargahi. Mr. Chibadet.
Yes, ma'am. May I pull the podium back here, because I'm over.
You may. Yes, sir. If you wouldn't mind, pull that mic down just a little bit. I don't know why it's not working well today. It's not, but. Will you test it now?
Hello?
Better?
Hello? Hello? Hello?
All right. We'll get it fixed, but. Yes, sir, what would you like to say?
Judge, thank you. Please support counsel. I think first of all, the record clearly reflects that this was a negotiated plea. The first count in the indictment originally charged my client with aggravated arson and felony in the first degree, in that he was alleged to have created a substantial risk of serious physical harm to a lieutenant Thacker of the fire department. The plea actually that was entered to count one, what we commonly refer to as the legal figure, in that we pled to A2 section, which is causing physical harm to any occupied structure. It's abundantly clear that the property of Mr. Berger, the old Jackson Brewery, was a vacant building used as a warehouse. I would like to add, while we have no problem with the state making their comments in reference to Mr. Bose, I think the record should reflect that my client, Mr. Dargahi, was arrested first, and that's how the identity of Mr. Bose came along. I believe the state believed, and I will not disagree, that my client was more responsible for this incident than Mr. Bose. So for whatever reason they gave, it was not because my client was not cooperative with the fire investigator, because he clearly was. He was arrested first, he gave a detailed and lengthy statement to the fire investigator, admitting his role in this offense and what happened. As it relates to the fire itself, we offer no excuse, no explanation, try to diminish the significance of the event itself. There was no, as Mr. Berger indicated, my client did not know Mr. Berger. He had no animosity towards Mr. Berger. There was no financial motive for this incident to have occurred. And while it obviously is correct, this became a very, very large fire, I think we need to put some of the context that plays the floor. I don't believe that either one of these young men ever intended for this fire to develop the way it did or get out of control and cause the damage that it did. Keep in mind that neither one of these young men had a specialized training or knowledge in the field of fire. I went out, I've seen many, many photographs, and we actually went out and visited the site of this, the Jackson Brewery. And clearly the fire started on the first floor. The second floor was above it, and there are 1 foot thick concrete floors. Then there is a third floor and then an attic. The fire was started in what they call the left rear area of the first floor. There was wood put in the pile and it was lit on fire. Charcoal fluid, lighter, was used to help ignite the fire. Now, they make reference to that in some of the reports that we received. But let's make it abundantly clear, the charcoal was a lighter fluid. All it did was help the fire to grow faster, not grow bigger. Just like when we started grilling home with fire with charcoal lighter. Yeah, it goes quickly, and then the charcoal lighter fluid burns off, then the charcoal burns. So the lighter fluid had nothing to do with the size of the fire. That was totally up to the fuel load of the building to burn. They also make reference to some propane tanks. I would submit, Judge, that that is in fact a red herring. There are pictures that reflect that there were a couple regular grill-sized propane tanks in the area of the fire. I'm not sure whether one pictures are staged or not, but I kind of missed placing those near where the fire started. However, the fire investigators never seized either one of those propane tanks. They never had them examined at all. The fact of it is that propane tanks, and this, we hired an investigator, and that was one of my specific areas of inquiry with them, is what is the chances of a propane tank exploding? Because that's one of the things that they were saying. Gee, there was a chance the fire would be heard as exploding. It's our belief that the tanks were empty. There's no evidence to the contrary, because they were never held as evidence or inspected. Propane tank, now Mr. Berger referred to a large propane tank that was on the second or third floor, but there's not even a picture of it. There's no reference in that to that tank at all in any of the Harston investigators' reports. The only propane tanks they're talking about are two that were on the first floor where the fire originated. Propane tanks have relief valves. When the pressure builds up due to heat or whatever, the relief valves let the propane out of the tank. Propane is heavier than it then sinks. So it would only burn for a very short period of time if there was even any propane in the tank to begin with. So to suggest that those are a risk of explosion, I think is very candidly disingenuous. There was a 1981 Department of Energy study that indicated that a person's chances of dying from a propane tank explosion are 1 in 37 million. The chances of dying in a commercial air flight is 1 in 35 million. So the chances of an explosion of a propane tank is infinitesimally small and certainly does not create a substantial risk of serious physical harm. I talked to the guy where I get my tanks and my grill filled up, Ward's out of Race Road, Glenway, I think the prosecutor knows where it is. And he's been in business there for over 35 years. He's indicated he never has ever heard of a propane tank exploding. Whenever there's an explosion, it's usually because, for example, you turn your grill on, there's a leak in the hose, or it's left on in the fire, and the propane goes up in the enclosed area. So that could simply not be the opportunity here. In fact, they indicated, our experts indicated, that there is a zero chance of an empty tank, propane tank exploding. These are experts with engineering degrees and substantial experience in reference to fires and propane explosions. What's also interesting, Judge, if you will, is the way this fire developed. As I indicated, the fire was started on the first floor, on a concrete floor with a concrete ceiling above. It was over, I would suggest, like in the back left corner of this room. Approximately in another area, and that's where it started, with a bunch of wood and stuff piled up. It then goes up to the ceiling, crawls across the ceiling, and goes up a steel stairwell to the second floor, the third floor, and then on up to the attic above that. I think this one further back here substantially, if I may approach that. This is a picture of the prosecutor gave me in discovery. The fire having started over in this area back here, goes up to the ceiling, comes across, and then goes up that chimney, up that stairwell, and that steel stairwell. It created what they refer to as a chimney effect. In the actual area, and then it goes up, and it caught some wood beams and other stuff on fire up on top of the building, in the top floor of the building, and that's where the fire really became involved. Not down on the first floor. In fact, the pictures they showed us in the discovery, we went, there's still wood on the roof, on the floor in the room where the fire started on the first floor. It never got hot enough in that room to even burn up the wood that was in that room.
Mr. Sugarbaker, is this of any consequence? Only because
I'm sorry.
your client has admitted to the fire.
Yes, ma'am. Yes, ma'am.
So at this stage of the proceedings, whether it went up the steps or on the first floor or the third floor, is it of any consequence that there was significant loss in this case as a result of fire?
There is not. That is not the issue.
Okay.
In the reports, though, in the PSI that was submitted by both Mr. Berger and the firemen, they addressed those issues, and I thought they needed to be responded to so that the court had what our version of it is, as well as what their version.
Thank you.
So that the court would not be, in my opinion, misled by that. Mr. Berger indicates that it's their goal to destroy this building. That is totally inaccurate from our perspective. But I will move along because I think the court understands the point I've made, and we're always hopefully on the same page. So anyway, I don't think these two young men, without any specialized training or education, had ever any idea or be expected to have any idea that this fire could develop to the extent that it did. So what I've indicated is the risk of fire. At no time did they ever indicate in anything but the indictment that there was a substantial risk of serious physical harm to firemen. The bill particulars didn't allege that, fire investigators reported did not allege that. What happened was, when the fire department responded, Lieutenant Fecker, they did what they call a size up. That is to determine what's going on here. They then made a determination, and he opened the reports reflect he opened the front door, was open for observation. They arrived at 4:24 in the morning. 4 minutes later, they declared it to be a defensive fire. It was offensive and defensive. Defensive meaning that we're backing out. We're not going inside. They didn't believe anybody was inside. Their procedure manuals indicate that fire should be offensive or defensive. This was defensive within 4 minutes after arriving at the first unit. Their manual provides we may risk our lives a lot to save lives. We may risk our lives a little to protect salvageable property. We will not risk our lives at all to save what is already lost. Point is, they went defensive immediately. That means that they withdraw and maintain a safe distance from the building outside of the collapse zone. I would suggest that we're all aware that different occupations and professions have certain inherent risks. We have a Marine on the ground in Afghanistan, Navy SEALs, policemen, fire bureau, people in active guard. But fortunately, the fire department followed their protocol to minimize the risk of any physical harm to any firemen, and fortunately, there was none. The fireman and Mr. Berger both referred to the fact that they did not believe that there was any remorse, that the only thing that he was remorseful about is getting caught. I would beg to disagree with that, Judge. First of all, my client accepted responsibility for the time he first came in contact with the fire investigator. Gave a lengthy and detailed statement to them. I think it's 60 or 70 pages that I had transcribed. At the last time we were here, this letter was given to the fire investigators. Mr. Dargai drafted that letter and signed it on his own. I had zero input into that letter. In the statement that he gave to the fire investigators, he accepted responsibility for his actions, admitted his role, and he pled guilty. Accepting the error of your ways, acknowledging your guilt, I would suggest is often referred to as the first step on the road to rehabilitation. In his statement to the fire, referring to the damage to the building, my client said, quote, "It makes me sick to my stomach. If anybody who had been injured or harmed in any way by my actions, I don't know how I live with myself. In fact, if there's any way I could write a letter to all the men and women who responded is, apologizing, I would like to do it." He has done that. My client, I was already remorseful about it. Now I'm just even more remorseful about it. Then the investigators, while they make their statement in PSI, in their interview with my client, investigator said, "Did you intend for people to get hurt when you set this fire?" My client, absolutely not. Put propane tanks near the fire to make fire bigger, not to hurt anyone. Investigator, this appears to be a bad decision that was made by a decent person. Did you want to hurt people by this fire? My client, absolutely not. The investigator, you don't strike me as some callous, unemotional fire setter that doesn't care about human life. When given the opportunity, I will say that you were completely cooperative and forthright. That's what the fireman told him in the statement my client gave. My client says, the first lesson, try to right the wrongs that I did. The investigator then said, I'll speak on your behalf. And I will make sure that the right people that need to know that you were forthright and honest about your part in this, and that the intention was not to hurt people. This is a young person who seems like a good guy who made a bad choice. The investigator, I've got no problem recommending a bond for you. You're nonviolent, you have no history, you've been cooperative. Investigator, you're not a bad guy, okay? You just made a poor choice. You made a decision. I get that. So try not to be too down on yourself. What you're showing me is you're a person with a conscience. That's what the investigator said in the recorded statement, not what he said in the PSI. Moving on. I reviewed the pre-sentence report, and I would concur with what they set forth on page 8, final page of that report. And that is that the Ohio Risk Assessment System Community Supervision Tool suggested the offender, that's Mr. Burkeye, presently has a low risk of recidivism. Based on the offender's risk for rearrest, supervision and treatment recommendations include minimum supervision or non-reporting supervision. Then they list the ORAS scores, all of which are low. In reviewing the sentencing guidelines, under 29.12, B, factors that make the offense more serious, I would submit that not one of those four apply in this case. In section C, which refers to the less serious factors, 1, 2, and 4 do not apply. Strike that. That my client, there are less serious factors, and that my client did not intend to cause physical harm to persons, but he did property. In reference to the matters of likely to commit future crimes, not one of the factors that indicate a likelihood to commit future crime applies. And in reference to section E, not likely to commit future crimes, I would submit that all 5 of those factors apply. And also in reviewing the psychiatric report, they indicate on page 11, with regard to the referral question, it is my opinion that Mr. Durgai is in need of intensive treatment programming to address his poor decision-making, coping skills, deficits, lack of insight, maladaptive behavior patterns, impulsivity, and mental health issues. And then they go on to say that they believe that the Franklin County Alcohol, Drug, Mental Health Board would be an appropriate referral source. Obviously, Mr. Durgai had serious traumatic brain injury as a younger man. That is not being tendered as any excuse in this matter at all. We make no excuse for his conduct in this case. We simply ask you to do the same thing that, in essence, Mr. Berger did, and apply the law and the sentencing guidelines to this case. We believe that if you do apply those guidelines and sentencing factors, we request that you place Mr. Gargano on probation with whatever conditions the court deems and feels is appropriate. That's all we have in the
Thank you. Is there anything your client would like to say?
Yes, Your Honor. I would just like to take this opportunity to once again express my deepest remorse and regret for what's occurred. I'd like to apologize to Mr. Berger for all of the financial losses that he's incurred as a result of my actions. I just ask for mercy so that I can move on with my life. Thank you.
Thank you, Mr. Roman.
Hey, please, Court Guard, very, 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 But I'm just gonna incorporate a lot of things that Mr. Schibbecker said in his statement as well in the mind. Fact of the matter is, Cameron's a 31-year-old kid. Your Honor, he acted like a kid that day. He's a grown man. And quite frankly, he made some very, very poor judgment decisions. Ones that he could take back, he absolutely would. Your Honor, Cameron, one of the things that stands out to me with regard to Cameron is his lack of record. The court can see that Cameron's never been in trouble. His parents are here with him today to support him. Your Honor, when this was going on, he had a job at Goodfellas, he was working there. He simply lost that job, he's doing part-time work right now, Your Honor. It came in group. He's got a job actually lined up, right after this, Your Honor. It's gonna be a two-man truck moving from him. Went to Green High School, Judge's father.
Hold on, I'm sorry. Court.
Absolutely. Your Honor, Cameron's a father. He's got a child. One that, quite frankly, since this case has been going on, he's been getting back to that child's life. He's becoming more of a father figure. I believe a lot of this has put things in perspective. But the fact of the matter is that day, Cameron made a huge decision to do what he did. He's taking responsibility for his actions, Your Honor. One of the things I think that needs to be brought out with regards to this case is, right after this happened, Cameron was apologetic. He was helpful. And that's one of the reasons why this case, why Mr. Gross was given case consideration with regards to Your Honor. For almost 2 years, this case has been going on. He has followed everything this court has asked of him to a T. He's been on EMU for 2 years. Your Honor, one of the things that I really want the court to understand here is while I absolutely sympathize with Mr. Berger and what was put on and what happened to his building, these two kids absolutely did not go in there with the intent of burning down our store. There was no intent for that. These were two men who went in there and made an absolutely big mistake. Reckless, absolutely. But there was absolutely no intent to burn down that building. The court looks at the PSI. I want the court to understand that Cameron stands in front of you convicted of a felony of the 4th degree, the second lowest level felony. The court is very well aware of the purposes and principles of sentencing. Looking at those, Your Honor, I don't, with regards to his recidivism, less serious, more serious, if the court applies the principles of sentencing, it's our belief that Mr. Rose should be sentenced to probation. Prosecution cannot oppose it. The court's well aware. Your Honor, I would like to rest on that. And I do know that Cameron actually has something to like to report.
All right, thank you very much.
It's a, Your Honor, it's a statement that's he prepared, it's on his phone, if that's okay, we can read that.
Thank you.
I would like to express the depth of remorse and regret for what has transpired in the evening that brings us here today. Due to court responsibility in decision making, I allowed myself to be in a situation that turned into a devastating event. One that I had not expected. One that I live with remorse and regret to this day. This terrible ordeal has taught me a valuable lesson of where I stand in the world and what my values are. Their importance of my voice and the necessity for calling for help when I cannot stop someone from doing something silly. Myself. To the victim and to the city of Cincinnati, I apologize profusely for being a part of something that took away a piece of this city's history. I'd like to think that the lessons that I've learned over the past 2 years, and with the introduction of my child in the world, and the lessons that she has taught me about the importance of being an honorable human, that I've experienced a tremendous amount of growth. And these lessons, and my hope is to be given an opportunity to be on probation, to work towards becoming a productive member of my local society. Thank you.
Thank you. All right, is there anything else from the defense?
No, Your Honor.
Thank you. Mr. Clark, anything else?
Just to clear the record, and to make clear, Mr. Berger, that was the mitigation section whereupon the defense attempts to place themselves in the best way. I think that he just wanted to make sure that he understood that that was something that they were trying to do. I would address just a couple of small things that should mitigation, regardless how the fire progressed, regardless where it went, etc. The problem here is once you pile wood and you set a fire and you admit to it, Judge, the damage is foreseeable. I mean, whether it's a small fire in the corner or the whole place coming down, once you do that, you're responsible for what occurs. So, and these were two grown men. With that said, again, the plea we were able to fashion the input of our victim from Lieutenant Fector to also Mr. Berger, so we asked for an appropriate sentence based on what we know about this matter. Thank you.
If the two gentlemen could come to the podium and pull it back closer to the court.
Fine, Your Honor.
That's great, thank you. And so I want to address Mr. Dargahi and Mr. Bose. As I look out and read the room, I'm able to see the pain, the anguish that Mr. Berger has endured for the last 2 years on his face and in his voice, as well as the anger of Mr. Terrigan as he feels for his friend's loss. But in addition to that, I have been able to discern the pain and anguish on the faces of your loved ones. You caused that. You caused your loved ones to have to be in this courtroom, have to live through the last 2 years, just like Mr. Berger. That is not lost upon me. I am incredibly disappointed to know that 2 young men with no record, intelligent, would be involved in such an offense that would cause pain to anyone else. As you stand here today, you are two productive members of our society. But when I look at these pictures that you took of yourselves on the night that this happened, and this picture in front of the fire, during the fire, with the caption, "This should be an album cover." And this picture of the fire with the caption, "A little arson and anarchy never hurt anyone." It begs the question, about your values, who you really are. Are you these gentlemen standing before me in well-dressed and mild, or are you these gentlemen? See, it's easy to dress up, walk in court, talk mild-mannered, and fool someone. It's easy. But the saving grace here is that you showed us who you were that night with these photos. Social media. In this picture, the news coverage of the breaking news historic warehouse destroyed by flames. See, this is what Mr. Berger has lived with in his heart and in his mind for the last 2 years. Do you get that?
Yes, yes, sir.
I know there has been a lot of negotiation on both sides. And these cases, Mr. Berger, they take time. During the pendency of this case, we were in the height of a pandemic. And so the court was forced to have many continuances. I've been here 9 months. So I know you've been dealing with this 2 years. I've been here 9 months. And it was my intention to bring closure to this for everyone involved, not just Mr. Berger, but also for Mr. Gargahi and Mr. Voss, and your families. At the end of the day, no matter how disappointing, how angry, how painful this is, and what you did, the court has to and will always follow the law. This court is not about being a rogue court and going off of emotion. I have to take in consideration and welcome the opportunity to take in consideration the victims that come into this court and how they feel and what they say and consider their loss. And in this case, it was significant. You may think it was just a warehouse, but it was more than just a warehouse. It was an iconic building. It was a historic building. And while it may not have meant much to you, or maybe not even looked like much, it was of significant value to someone, to many people. And it's gone. Because, why? I still don't even really know why. I know I talked to you at the plea colloquy, and I don't know that you even know why. Do you?
No.
What we have to do in this life is we have to face the consequences of our actions, which is why we must do the very best we can as individuals to make the best decisions we can at the time. You know, and you knew on December 15, 2019, that this was not the best decision. You knew that then, didn't you?
Yes, ma'am.
It's not just 2 years later. You knew it at that moment. But whatever it was that caused you to override your good judgment, I don't know. And it begs the question, would you do it again? Maybe not burn someone's kind of business down or building, but it's that very thing that you're gonna have to ask yourself, no matter what happens here today. How did I override what I know to be wrong? How did I come to that point? I don't know the answer to that. But I think that's something that you're gonna have to do some soul searching about and come up with a conclusion. I want you to know that you both will have to register as arson offenders. Do you understand that? You're gonna go on a registry.
We have executed those warrants, Your Honor.
I see that. All right. Nancy, counsel for just a moment.
Yes, that's no problem.
The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to, number one, protect the public from future crime by this offender and others similarly minded, and two, to punish these offenders using the minimal sanctions that the court determines accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I have considered and reasonably calculated these sentences to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of these offenders' conduct and its impact not only on the victim, Mr. Berger, but also on society, and to be consistent with the sentences imposed for similar crimes committed by similar offenders. I have also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, Mr. Dargahi and Mr. Bose, as to count 2 for Mr. Bose, arson felony in the 4th degree, and Mr. Bose, count 5, arson, a felony of the 4th degree. Did I say that right?
Sure, just, Mr. Dargati, did you count one to an F3?
Yes, F3, and the F3, and count 2, arson, F4.
Yes.
And Mr. Bose, count 5, arson.
Yes.
Yes, thank you.
Sorry, just for the
Nope. Appreciate that. All right. I did not do that for dramatic effect at all, I apologize. All right, as to Mr. Dargahi, the court finds, based on the felony sentencing factors, that the presumption of prison is overcome. Accordingly, I am sentencing you to a term of 40 years community control. Although Mr. Berger did not request restitution, you will pay $15,000 in restitution, joint and several with your co-defendant, $2,500 fine, costs remit. If you violate the terms of community control, I will sentence you to 36 months in the Ohio Department of Corrections. Do you understand?
Yes,
Mr. Boss, I sentence you to 4 years of community control, restitution $15,000, joint and several with your co-defendant, $2,500 fine, cost remit. If you violate the terms of community control, I will sentence you to 18 months in the Ohio Department of Corrections. Do you understand?
Yes, Your Honor.
Both of you will stay away from Mr. Berger. And anything else, counsel?
Judge, not as it relates to the sentence, it only relates to my client, Mr. Dargai, is now living in Columbus, Ohio, Franklin County. I'd like to ask.
I will have an issue with transferring the supervision to where he lives.
Thank you, thank you.
All right. Also, you have executed the notice of duties to register as an arson offender under revised code 2909.14. Counsel, do you want me to read these to your client?
It's not necessary, I don't know how to apply it, what we'd like to have is a copy back, so you can take it and register appropriately.
Just be pursuant to the.
I have to read it.
She has to read it to both.
Oh, I hear that.
Number one, you have been convicted of or plead guilty to an arson-related offense as defined in revised code 2909.13. You are required to register in person with the sheriff of the county in which you establish residency within 10 days coming into that county, or if occupying a dwelling for more than 3 days in that county. Number three, you are required to provide the sheriff certain information, including your social security number, full name, and any alias you use, your residence address, information regarding the offense of which you were convicted or pleaded guilty, a description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place where you are employed or attend school, any driver's license number, commercial driver's license number, or state identification number issued to you, the license plate number of each vehicle owned or operated by you or registered in your name. The vehicle identification number and a description of the vehicle must also be provided to the sheriff. Number four, you are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of registration. Number five, you are required to remit a registration fee of $50 to the sheriff unless the fee is waived. Number six, after the date of initial registration, you are required to re-register annually. You must update and/or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially registered. Number seven, you are required to pay a re-registration fee of $25 to the sheriff. Number eight, if you change your residence address, you shall provide written notice of that change to the sheriff with whom you most recently registered, and to the sheriff in the county in which you intend to reside. You are required to comply with all of the above described requirements until your death, unless your sentencing court determines otherwise, and I'm not determining otherwise at this time. I see that both Mr. Boss and Mr. Dargahi have executed these forms. Are these your signatures?
Yes, Your Honor.
All right. And I'm going to sign and give you a copy. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to you at no cost to you to help you. Do you understand?
Yes, Your Honor.
Anything else for the council?
Nothing on behalf of Mr. Norgay, we appreciate your consideration, Your Honor.
Okay, I have a question.
Just, did you order any sort of treatment for the child?
Just a second. Well, they'll both be on community control, and I will order treatment as recommended by the probation department. So it looks like the defendant's all right, if there's nothing further to come before the court, you must report to probation immediately. Thank you.
Thank you, Your Honor.
Mr. Chairman, State Council, Tennessee, Mayor.
Sorry, I didn't want to back. I'm sorry.
Sir, yes, I still agree, Your Honor.
Oh, okay, thank you.
If I can use it. I don't know.
Oh, no, you can't.
All right.
So I don't know.
This Howard talks, you can answer. She might know more.
Okay. Alright, I have a case that there's a Zoom. I'm doing some of the cases, I've never had a case here, I've never done it. We got another email or this,
Is it a criminal matter? Did you not get anything? Are you the attorney?
Yeah.
What's your case name?
The state of Ohio is Donnie, D-O-N-N-I-E, last name Powell, H-O-W-E-L-L.
Okay, yeah, Lawrence should be sending that out. Did you get an email from her?
Who is it?
Lawrence is the bailiff.
She is off, but she's going to stop now.
Okay. It would just be an email, right? Yeah, we don't know.
I'll let her to put it out, she already has it.
Okay, and then